legal pond.
Welcome to today's episode of the Legal Pond. This episode is going to be on one of the vitiating factors, one of the tools that can vitiate the validity of a contract or the effect of a contract. And then what we are looking at today is misrepresentation. Let's get started.
The legal pond.
Welcome back. As stated earlier, today's video is going to be on misrepresentation. Now, you and I know from our discussions under terms of contract and mistakes that when the parties are about to enter into contract, they engage in negotiations. And at the negotiation stage, they make statements, some of which are meant to be binding, whilst others are not binding. Now, when the statement is meant to be binding, we refer to it as a term. If the statement made is not meant to be binding, it is a mere representation. Now, we noted from our previous discussion that mere representations only induces the parties to enter into the contract. They are not in themselves terms of the contract. Now, if at the end of the day, we realize that some of these mere representations that were made has turned out to be false, was made falsely, then that particular mere representation which has turned out to be false is a misrepresentation. So this topic focuses on misrepresentation. Now, when a misrepresentation is made, it doesn't render the contract void because the term that has been represented or the statement that has been represented is not a term of the contract. Therefore, misrepresentation, when it occurs, does not render the contract void. It only renders the contract voidable. So in the case of Eglinton versus Fitzmaurice, the court said the effect of misrepresentation is that it undermines the mutual consent of the parties to enter into the contract, but does not necessarily negate the validity of the contract. Therefore, it only renders the contract voidable and not void. Now, for misrepresentation to be operative, to render the contract voidable, three major things must be established. The first thing is that the defendant must have made a false statement, which is a statement of fact. He must have made a false statement, which is a statement of fact. Now, what is a statement of fact? Now, a statement of fact is an emphatic statement that is made by a party. So, for instance, if you ask me, how much is iPhone 15 Pro Max? Then I tell you that iPhone 15 Pro Max, oh, I bought one yesterday. The price is 1,000 Ghana cedis. Now, let us compare that to when you ask me how much is iPhone 15 Pro Max, then I tell you iPhone 15 Pro Max will be around 800 Ghana cedis. Now, these two statements that I've made, you realize that I was very emphatic about one of them, and the other one, I just expressed an opinion. So you realize that what the defendant have said, which we claim to be a misrepresentation, should be something that he stated it as a statement of fact. It should be something that he stated it emphatically. So when you look at the case of Bicet versus Wilkinson, a vendor who was selling his land told the buyer that if you manage this land well, you are going to be able to hold or rear about 2,000 sheep on the land. Now, this statement turned out to be false at the end of the day because it couldn't hold the estimated number of sheep. Now, the buyer wanted to rescind the contract on that grounds, but the court said that what the seller said was conditional in the sense that he was expressing an honest estimate, which could not be held as a statement of fact because he said, if you manage it well. So the question is, what is the estimation of proper management on the land? So that makes it a statement of opinion and not a statement of fact. Now, let us compare that with the case of Smith versus Land and House Property Corporation, where someone wanted to purchase a particular property and the seller told the buyer that the tenant who is in this particular property is the most desirable tenant. Meanwhile, that tenant actually had arrears. So what it meant was that he emphatically said that the guy was desirable tenant, knowing very well that he wasn't desirable. In that sense, what he has said is a statement of fact, which could actually graduate into what? A misrepresentation. Now, there are certain statements which do not generally qualify as a statement of fact. One of them is opinions. Statement of opinion does not amount to a statement of fact, and because of that, generally it cannot be a misrepresentation. However, if an expert gives an opinion, it will be considered as a statement of fact that can graduate into a misrepresentation. So when you look at the case of Esso Petroleum versus Marden, where this guy wanted to rent a particular filling station. Now, the person who advertised it to him told him that you can sell about 200,000 gallons per day. It happened that this particular filling station couldn't sell up to the 200,000 gallons per day. And you could also see from the fact that the guy actually entered into the agreement because of that particular statement made by the expert. So that particular opinion expressed by the expert was considered a statement of fact, which amounted to a misrepresentation. Another thing that do not amount to statement of fact is statement of future intention. Now, if I make a statement that anytime I get money, I'll build a house. Now, such a statement generally will not be considered as a statement of fact because there is this common sense that no one knows the future. Now, having that in mind, if a person makes a statement of future intention and that person knows that what he is saying is actually something that he will not do, it is something that he had intended not to do, then even though it is a statement of future intention, it will amount to a statement of fact. So for instance, if I tell you to give me 10 cedi to go and buy food, and I end up using that 10 cedi to buy shirts, or I know very well that I need that money to buy shirt and not to buy food, then even though what I said was a statement of future intention, it will still amount to misrepresentation. So you look at a case like Argentin versus Fitzmaurice, where this company issued a prospectus. And in the prospectus, they said that whatever money they are going to gather will be used to renovate their buildings and expand their businesses. Not knowing in their minds, they knew that they were going to use the money to pay debt. So that statement made in the prospectus was a statement of future intention. However, because they knew it was false right from the beginning, it amounted to a misrepresentation. Another thing that do not qualify as a statement of fact, and because of that cannot be misrepresentation, is silence. If I do not talk about something, generally, it is not misrepresentation. So for instance, you are coming to buy a car from me. The car has a fault. I didn't say anything. I just kept quiet. Me keeping quiet doesn't mean I have misrepresented you. There are 3 exceptions or conditions under which silence can amount to misrepresentation. What are they? 1, when the contract is a contract ubarima fide. When we say a contract is a contract ubarima fide, then it means that that contract is such that the parties must act with utmost good faith. They are contract that mostly the major information in the contract is with one of the parties, such that if he does not disclose it, the other party will lose. Example of such contract is insurance contract. The insurer must make sure that he has disclosed every important information to the insured. The same way, the insured must also make sure he has disclosed such information to the insurer. So if it happens that you failed to tell them something and it appears that those things were things that you failed to disclose, then your silence will be a misrepresentation. So you can look at cases like Carter versus Bohem and the case of Walters versus Morgan. Another condition under which silence will amount to misrepresentation is when your silence distorts truth. So this happens when you initially made a true statement, but circumstances have changed. So your true statement have become false. In that sense, you must tell us the change that has happened. Else, if you fail to tell us the change that has happened, your silence to tell us that change that has happened would amount to misrepresentation. So you look at the case like With versus O'Flanagan, where the defendant had originally indicated that his medical practice could yield him £2,000 per year. At the time he said it, it was true. But going forward, his health condition changed, so he could not make that kind of money per year. But he failed to disclose the change that has happened. So you see, this time, his silence, his failure to disclose, his silence has amounted to a misrepresentation because it has distorted a previous truth. Another thing that will make silence amount to misrepresentation is partial disclosure. Now, the thing is that when you keep quiet, you have not made misrepresentation. But if you want to talk, then talk everything. If you want to put it that way. If you want to speak, then you have to tell us everything. If you make partial disclosure and leave some behind, the things that you've left behind, the things that you've remained silent on, may amount to misrepresentation. So you look at a case like Curtis versus Chemical Cleaning and Dyeing Company Limited, where this lady sent her garments, wedding garments, to a laundry, and then they gave her a receipt. Now, the receipt stated an exclusion clause, and the clause was supposed to be interpreted to her. Now, the person interpreted the clause as meaning that the company will not be liable if at the time the lady comes back for the garment, there are some damages to beads in it. So that is how he limited the clause, not knowing the clause actually covered all liabilities that will arise, irrespective of how they arise. So he realized that the guy did partial disclosure. He did not disclose everything. And in that sense, the part that he did not disclose was considered as a misrepresentation. And because of that, in that case, the company was not allowed to rely on the exclusion clause, because at the time the lady came back, it wasn't the beads that were destroyed. There were actually stains in the clothes, which the clause also covered, but they did not tell her. So that was a partial disclosure, which amounted to a misrepresentation. The second thing that will make misrepresentation operative is that the statement which has been made must have been directed to the person who is claiming to have been misled. So if the statement was not directed to you, then you cannot say you have been misled. So the statement must have been directed to the plaintiff. So you look at a case like Peak versus Ghani, where this company issued a prospectus. They published a prospectus, and then in the prospectus there were some false statements. But this guy went to, invest his money in the company by getting access to the prospectus in the open market. He was not actually part of the allottees to whom those prospectus were issued for. Now, he discovered the misrepresentations in the prospectus. The court said that no, those things in the prospectus was not directed to him because he was not an allottee. So, for instance, if you hear me telling someone that, oh, iPhone 15 is 12 Ghana cedis, then you heard me telling someone, you were just passing by and you heard me telling someone that iPhone 15 is 12 Ghana cedis, then based on what I am telling the person, you go and enter into a contract for iPhone 15, and then you later realize that it's not 12 Ghana cedis, but it is 35 cedis. In that sense, you cannot claim misrepresentation against me because whatever I told the person was not directed to you. That is what this point means. The third element is that for a misrepresentation to be operative, the plaintiff must have been induced by the false statement made by the defendant. So if you were not induced, then there is no misrepresentation. So what is inducement? Now, for a party to be induced properly, there are certain principles that the court looks at. One, proper inducement happens when the misrepresentation occurred before or at the time the contract was concluded, and not after the contract was concluded. So you look at a case like Hosford versus Thomas, where the plaintiff had charged the defendant to prepare a gun for him. Now, when he prepared the gun, there was a latent defect, but then he did not disclose it. He did not tell him. This guy took the gun, wrote a letter back and told him that, oh, your gun is so nice. It is made of proper metal and all that. Now, later the gun exploded, and then he wanted to sue. But the court said that the defect that you discovered on the metal is something that you discovered later. So it wasn't part of the things that induced you to buy the gun. It wasn't part. So the misrepresentation happened after the contract has concluded. What actually lured you was the fact that it was made of proper metal. And yes, it was actually made of proper metal, so there's no misrepresentation. Another thing that the court will look at to determine whether you have been induced or not is whether you made a verification. So for instance, if I ask you to verify the goods and then you come and verify the goods before you buy it, then you cannot come and tell me that I've made misrepresentation, unless the defect on the goods is something that you cannot actually discover, even with reasonable verification. This was noted in the case of Smith versus Chadwick. Again, another thing that the court looks at to be convinced that you have been induced is that the court will look at whether you were aware of the misrepresentation. So if you know very well that what I am telling you is not true and you still go ahead to enter into the contract, then you cannot later come and say that there have been misrepresentation, or you have been misled, or you have been induced by my misrepresentation. The reason is that you know about it. This was also noted in the case of Atwood versus Small. Now, the next thing we are looking at is the kinds of misrepresentation. There are three major kinds of misrepresentation. The first one is called fraudulent misrepresentation. The second one is known as negligent misrepresentation. And the third one is known as innocent misrepresentation. What are they? what are their elements, and what are their effects. Now, fraudulent misrepresentation arises where a person makes a false statement knowingly without belief in its truth, or recklessly without caring whether it is true or false. So if a person makes a statement and he knows that what he's saying is false, or he says it without belief in the truth, then it means the person wants to defraud. And that is what makes up fraudulent misrepresentation. This test was given by Lord Herschel in the case of Dairy versus Peak. Now, the effect of fraudulent misrepresentation is that because fraud vitiates everything, one, the innocent party or the misled party can rescind the contract. Two, he can claim damages. So two remedies are available when fraudulent misrepresentation happens. One, you can rescind the contract, and two, you can claim damages. This was noted in the case of Doyle versus Obi. The next one we are looking at is negligent misrepresentation. Now, negligent misrepresentation arises where a party to a contract makes a false statement carelessly, and as a result of that careless statement, it leads the other party to suffer losses. Now, the element that needs to be established for this particular negligent misrepresentation is that one, the misled party must show that there is a false statement made, and then two, the person who made, or the defendant who made the statement, failed to exercise reasonable care even though he owed that duty of care to give a true statement. That means there must be some kind of contract between the two of them, which creates a duty on him. So you look at the case of Nocton versus Ashburn. The court said that for you to say that there is negligence misrepresentation, it is either you have a contract with the person and the contract creates a duty on him to give true statements, or you have a fiduciary relationship with the person, which charges the person to tell you the truth. So fiduciary relationships such as the relationship between lawyer and client, doctor and patient, and all those relationships, it lays on one of the parties the duty to speak the truth to the other party because he's the only person who has the truth. So if you fail to tell the truth, or if you make a statement carelessly, whilst you have a fiduciary duty to make a reasonable statement, then your careless statement will amount to a misrepresentation known as negligent representation because you have made a statement in breach of your fiduciary duty. The case of Candler versus Crane is one of those cases that also upholds that particular principle. But in Candler versus Crane, Lord Denning dissented and said that negligent misrepresentation should not only be limited to situations where the parties have a contract or a fiduciary relationship. It can also arise by way of special relationship. Now, what is that special relationship he was talking about? A subsequent case came to apply or explain that special relationship. The case of Hadley-Bine and Co. versus Heller Partners, where in that case the House of Lords established that a special relationship exists when one party possesses special knowledge or skill over another person and then offers to give advice. At that moment, that you assume the duty of giving advice, whilst you have knowledge or skills over the person you are giving the advice, it creates a special relationship between you and the person, and thus you need not be careless in making that advice, else whatever you say may amount to a misrepresentation, which is called negligent misrepresentation. So the court went ahead to say that if you have that special skill or knowledge over the person to whom you are making or giving the advice to, and you know very well that the person is going to rely on that advice, then that particular circumstance creates a special relationship between you and the person, and that you must not act carelessly. So you don't have to be in a contract before that special relationship arises. Now, the third thing to establish before negligent misrepresentation can arise is that the misled party must show that he has suffered a resultant loss. Now, where there is negligent misrepresentation properly established, it entitles the innocent party or the misled party to claim damages and also rescind the contract. So rescission is the main remedy. Then he may go ahead to claim damages where he has suffered special losses as a result of the careless or the negligent misrepresentation. Now, the next kind of misrepresentation we are looking at is innocent misrepresentation. As the name suggests, the person innocently makes a misrepresentation. So innocent misrepresentation arises where a party to the contract made a statement of fact which is false, but then he made it with honest belief in the truth. So when he made it, he believed that what he was saying was true, but it turned out that unknowingly to him it was false. That is when we say he has made an innocent misrepresentation. Now, the element to be established is that 1. There is a false statement made. 2. The false statement was made with honest belief in its truth. 3. It induced the misled party to enter into the contract. And then 4. The misled party relied on it. And then finally, there is a resulting loss. That is when we say there is innocent misrepresentation. Now, when innocent misrepresentation is established or it happens, the effect is that it entitles the misled party to only rescind the contract but does not have the right to claim damages. However, he can claim what you call indemnity. Now, the indemnity covers specific losses or expenses that have been made as a result of the innocent misrepresentation. So that is not damages. So unlike fraudulent and negligent misrepresentation, innocent misrepresentation does not allow the misled party to claim damages. They can only rescind the contract, and in some circumstances, the court may grant what you call indemnity to cover specific expenses made as a result of the innocent misrepresentation. You may look at the case of New Begins versus Adams. If there is any question regarding what you've done so far, you may send them to the numbers running on the screen, or you may drop it under the comment section for further clarity. Once again, I advise that you get the legal companion and then look at the questions and the answers in that material on misrepresentation. See you in our next video.
The legal pond.